Yes, I hope everyone has joined the webinar. A warm welcome to all the attendees who have joined the webinar. Uh, Before we start the webinar, I'd go about with a brief of myself and my team who have put together this webinar. Before we go any further, um, I am Sushant, a practicing lawyer in Telangana, and I had the occasion of appearing in many matters before the High Court, the Company Law Tribunal, as well as the Assistant Commissioner of Labour. The idea of the webinar emanates from the various questions posed by my clients on whether they can do a salary cut or whether they can terminate their employees in these tough times. And a lot of employees also had similar queries when their salaries were reduced, their wages were reduced unilaterally. And I thought it would be fit to do a webinar to help the management of companies and also the employees. And before we start, I'll just brief about the way in which we are going to go about in the webinar. We are going to first look at the laws that are applicable to these various industries and shops and establishments. Then I'll go about explaining all of you the applicability of these laws to various sectors, be it a factory, be it an industry, be it a shop or an establishment. Then we'll talk about the special the GOs granting exemptions to the IT industry. Then we'll talk about the special laws governing the situation we are in. Then the special government orders issued by the government of Telangana and the government of India. Then I would tell what remedies are available to an employee in these tough times if he is terminated or if salary is reduced. I will also explain to you at the end of the session the remedies, the corrective actions that an employer can take, and then we'll have a Q&A session. Now, moving on to the applicable labor laws. Although there are many labor laws governing the employee-employer relationship, I have concised only the ones that I deem are applicable in the current situation. A few of them include the Factories Act, the Payment of Wages Act, the Minimum Wages Act, the Payment of Gratuity Act, the Industrial Disputes Act, and the Telangana Shops and Establishments Act. Now, as you can see, Payment of Wages Act and Minimum Wages Act deal with wages, and they are laws enacted. One is enacted before independence, and the one Minimum Wages Act was enacted when it was deemed that the bargaining power of workmen was very weak. All the 4 acts that deal with wages are now going to be codified into the Code of Wages Act, and the Code of Wages Act has received the assent of the President on 8th August 2019, but the notified date is yet to be notified. Now, moving on to the Factories Act, this is a labor welfare legislation. It was it is a labor welfare legislation, and it was brought into force to protect workmen from the hazards they face during their employment, that is industrial and occupational. Now, this act defines what a factory is. It takes into account the number of people employed, and it excludes from the definition of a factory certain establishments like a hotel, a mine, a railway running shed, a restaurant, etc. Now, under the Factories Act, there is no express provision for the government to deal with an epidemic. There are only a certain provisions which deal with the outbreak of specified diseases that are specified in the schedule. Now, what happens if such a disease, there's an outbreak of such a, in the provision, it is stipulated that the manager is responsible for the welfare of the employee, and if if there's an outbreak, he has to notify the concerned factories inspector. It only provides for annual wages and it does not deal with wages in specific. Moving on to the more specific acts. Now, Payment of Wages Act is an act that governs, that protects employees who earn less than 24,000 rupees. So this is very important because each of these acts, we have to see if they are applicable to you and to what class of employees these acts are applicable. Now, Section 16 is amended every 5 years. In 2017, it was amended, and this act is applicable to any employee who earns less than 24,000 rupees. Now, again, Section 14 stipulates to whom this act is applicable. The applicability is of wide amplitude. It makes it applicable to various industries, as you can see on your screen. Now, another question arises as to what is a wage. A wage in general parlance and as defined in all the labor legislations is something that you pay to the employee if the terms of employment are fulfilled. Now, the reason I stress on the words terms of employment is because now an employer can argue that the terms of employment are not fulfilled. So that is the reason I have extracted this clause for you. Again, this is a labor welfare legislation, so it takes into account all the various deductions that you can make, and you cannot act in any manner contrary to the act. That is, if you want to reduce the wages and you take a decision that you want to deduct under various heads which are permitted under the act, that cannot be permissible, because the mode and manner in which a deduction should take place is clearly stipulated. Section 9 to 13 stipulate some of the deductions. Some of the deductions that you can make from the wages of an employee are on the grounds of fines, recovery of loans, damages, absence of duty. Under this act, there is a remedy available to the employee. He can approach the Assistant Commissioner of Labor if there's anything done contrary to the act. Now, moving on to Section 23, that's something called contracting out. In the recent times, I'm sure all of you must have heard that you should get the consent of the employee and reduce his wages. This provision deals with a contract which you enter into with an employee, and even if the employee agrees that he will receive a wage less than, or he will receive a deduction which is not, he will allow for a deduction which is not permitted under the act, such a contract is void. Now I'll explain more about the contracting out clause in some time when we move on to the Minimum Wages Act. Now, Minimum Wages Act is an act which is enacted in 1948. Again, explaining all these acts is with a specific intent to make you understand what are the laws applicable to your industry, to your establishment, and I have only culled out the relevant definitions and the relevant provisions. Now, Minimum Wages Act was brought into force when the workman could not really negotiate with his employer, and the bargaining power was very less. And it only defines what an employer is and what are the scheduled employments. Now, under this act, there is a minimum wage payable. So if your industry is a spinning mill, if it is a mine, if it is any of the industries specified in the schedule, or the ones that the state government is empowered to stipulate minimum wages, this act will be applicable to you. Now, what is a minimum wage is again the minimum wage rates are issued by the government of Telangana, So depending on your industry, the minimum wages are applicable. Now again, there is a contracting out clause here. The contracting out clause is a clause which specifically deals with a situation where you force the employee to receive a wage less than the minimum wage. Now, that is giving up his right under the act. That is impermissible. So, today, if you're paying a wage higher than the minimum wage, and if you want to reduce the wage lesser than the minimum wage, that is not permissible. So, at the end of the session and the remedies an employer can take, I will explain it to you in detail. Now, the Minimum Wages Act and Payment of Wages Act are applicable to a wide range of industries, establishments, and they exclude very minimal establishments. Now, Industrial Disputes Act is an act that governs the dispute between an employer and an employee. Any dispute, as you can see on the screen, any dispute that arises out of a discharge, dismissal, retrenchment, or termination would be an industrial dispute. Now, the key definitions would be, what is an industry? The clause is exhaustive, the section is exhaustive, and has always been a contentious issue. Like in the case of Madras, they said IT employees will come under the purview of the Industrial Disputes Act. There are contrary decisions on this, but so far as factories, establishments which manufacture, process, all come under the Industrial Disputes Act. And again, the exemptions, I will explain it to you as we go further. Now, as you can see that it has to be applied on a case-to-case basis, and we cannot say in a blanket manner that it is applicable to everyone. Now, the important amendment that Andhra Pradesh government had brought into force was the exemption of a managerial and administrative capacity personnel from the purview of the Act. So, if you have a factory, you have skilled, unskilled labor, operational, clerical, and technical people. But the managerial people who are in the administrative capacity do not come under the purview of the Act. Again, this is for the reason that all the laws are for protecting the lower rung personnel in any industry. Now, moving on to see, as the amendment exempts them, they are not entitled for any benefit or they're entitled to seek any relief under the Industrial Disputes Act. Now, what is a lockout? A lockout is a temporary closure of a place of employment. Again, if you say you do not want to work, you do not want to pay a wage to your employee during this lockout, if you consider it as a lockout, then there are various judgments which state that if the reason of the lockout has to be looked into before any dispute is resolved. Now, there's an industrial disputes tribunal that is stipulated and under the Act, and if an employee is dismissed or discharged without any reasonable cause, or if the tribunal finds that the dismissal is bad, it has the power to reinstate an employee also. Now, as you can see, there are various labor tribunals, national tribunals that are covered, that are established under the Act. Now, a retrenchment is defined as a termination. I would the common parlance that is used is a layoff that you use for a termination, but a layoff is different. A layoff is not a complete termination under this Act, and you can always you can terminate an employee, and that is called retrenchment. Now, the key difference being, in a layoff, you're just it is like keeping them on bench. You're paying them 50% salaries, but in a retrenchment, you are terminating the services. Now, the various sections that deal with the procedure for retrenchment and re-employment of workmen are seen on the screen. One more important provision that you can look into if you are looking into the act is a remedy that you can avail to reduce the wages of an employee by giving a 21-day notice to the factory inspector or concerned inspector. Now, if the whether that will be allowed will be on a case-to-case basis, and given the situation, in the worst case scenario, I hope you can look into that resolution also. Now, again, about the application of this act, there are different provisions for factories with 50 with a labor workforce of 50 or a labor workforce of above 100, and the applicability of the act is different. So the Industrial Disputes Act broadly covers any dispute in an industry, excludes a managerial and administrative capacity personnel, and it sets up various authorities you can approach. That is the tribunal, Industrial Disputes Tribunal, the Labor Commissioner, depending on the type of dispute. Now we move on to the most relevant act according to me, because considering the number of people who have joined this webinar and their industries whom I have perused, I can say that you should look into this act. The applicability of this act is very wide, and it applies to IT and ITES industry and many shops and establishments. So again, the meaning of a shop and establishment is very wide. A commercial establishment is also defined, and any business would come into it, excluding a factory under the section of a employee and other disputes. Now, broadly, as you can see, the definitions under the act: who is an employee, who is an employer. Now, what are wages? Again, the wages is defined as something that is payable if the terms of employment are fulfilled. Now, there are certain sections for shops, certain sections for establishments. Section 13 is one section that is applicable to shops, and it stipulates a closure of shop in public interest. Now, it does not talk about a pandemic or outbreak of an epidemic disease like COVID-19, but it is a generic clause. Now, moving on to the leave and the holidays in this act. Under section 31(2), a chief inspector can always notify holidays other than the holidays already mentioned in an emergency. Now, that comes with a rider. He can do it only for a certain number of days, and these are not holidays strictly, but I'm just enumerating the various emergency provisions in this act. Now, moving on to the more applicable sections. Again, this act also has deductions stipulated. As you can see on your screen, these are the permissible deductions you can make from the wages of an employee, and these are subject to a 50% cap. Now, any deduction you make contrary to this one can be claimed before the Assistant Commissioner of Labor. Now, two more important and relevant provisions. Section 41(7) talks about termination of services. Now, this section, read with the rule in Telangana Shops and Establishments rules, stipulates the mode in which you can terminate the services of an employee. So all HR managers attending the webinar, I request you to go through this once if you have time, and you can see the mode in which different class of employees can be terminated depending on their service. Now, this should be in writing, and the mode in which the termination should be done is also stipulated under the Act. And due to paucity of time, I could not put everything in the presentation, but you can always peruse the rules. There's a clear section on how you should terminate. And now Section 47 says the compensation payable or the notice that should be given. As you can see, the termination of an employee who's in service for not less than 6 months should be done by giving 1 month notice or wages in lieu thereof. Now, service compensation increases as the term of employment of the employee increases. Now, again, this act has similar provisions of contracting out. You cannot enter into a contract with an employee which is contrary to the act. Any right that accrues to an employee to whom this is applicable, you cannot enter into a contract, and that contract will be null and void. That is, any right in the sense of a deduction or a termination that accrues to him, you cannot do that. Now, the more important and relevant provisions, they're not in the slide here, are Section 48 and Section 51. To all the employees out there, if a termination you feel is illegal, you can always challenge the same, and that is under Section 48. If you feel the wages are not paid in time or there's a deduction in wage, you can challenge the same under Section 51 before the appointed authority. Now, who is an appointed authority? The appointed authority is the Assistant Commissioner of Labor, and under the Telangana Shops and Establishments Act. Now, the Assistant Commissioner of Labor is also the authority under the Payment of Wages Act, Minimum Wages Act, and they also differ on the nature of the claim. If the claim is higher, it might go to a Joint Commissioner of Labor. Now, again, the important provision in this act exempts the applicability to managerial employees. That is Section 73. This is again very important. I will pause here and explain what is a managerial position. So this act goes a little further and stipulates that an employee who has control over the establishment. Now, on a case-to-case basis, we have to see whether an employee is in a managerial position. Some people, only for the sake of designation, can be given the post of a manager depending on your organization. So a person who's given a designation of sales manager, but he does only sales promotion and he has no managerial work in the company, he would still come under the purview of this act, and he can still claim if he proves to the Commissioner of Labor that even though his designation includes a word manager, he never performed the duties of a manager, nor he had any control of the establishment. Now, we have seen all the relevant acts. I will not discuss the payment of gratuity, payment of bonus at this point of time. I'll only tell the exemptions granted to the IT industry, which is also relevant. Now, initially, the government of Andhra Pradesh had passed GOMS 22 in 2013, exempting certain sections of the Telangana Shops and Establishments Act from being applicable to the IT industry. Section 15, 16, 21, 23, and 31, I would not discuss now, as I don't deem them relevant, because they talk about the work hours and they talk about engagement, employing women at workplace and their safety. But Section 47 is of paramount importance because that was exempted from being applicable to IT industry. That is termination. Now, the government of Telangana has issued a new GO exempting the applicability of certain sections for a period of 5 years on 25/7/2019, as you can see. But the most important exclusion is they said that Section 47 is applicable to everyone. It's not excluded from being applicable to the IT industry. That is, Section 47, which deals with termination, is excluded, and um, all of the IT industry employers have to follow suit and follow the procedures stipulated in Section 47. Now, moving on, those are some relevant laws that I deem applicable to the present situation. And uh, now we move on to the more relevant laws everyone is talking about. What I don't think you must have noticed before are the laws that are on your screen: the Epidemic Diseases Act and the Disaster Management Act. Now, as is the case, no one expected, or it was beyond the expectation of many lawyers also, that they did not include a force majeure clause maybe in your contract. The epidemic, I'll just run through the relevant acts and then the important government orders issued, which deal with the current situation. The Epidemic Diseases Act B is a very archaic law, and it has only 4 provisions. As you can see, it empowers a state government to make any temporary regulations for preventing the spread of a disease. This is what it states. Disobeying any regulation would be an offense under Section 188. Now, what's an offense under Section 188? It has a maximum punishment of 1 month, but we will not go into it. But this act stipulates that disobeying the section would entail a penal action. Now, the Disaster Management Act is fairly new, we must say, and has more provisions. Now, again, what powers does the central and state government get under this act is a point of discussion. And as you can see, the act stipulates a National Disaster Management Authority, State Disaster Management Authority, and a District Disaster Management Authority. Now, the measures a state and central government can take are stipulated. As you can see, the section under which the state government has powers is Section 38. Now, I've only extracted the relevant provision, which the state government can make an argument saying that it has the power to give regulations, such as a regulation directing a private establishment to pay wages. Now, what is Section 38(2)(l)? It grants wide powers to it, and it says the state government can take any measures it feels expedient for securing the implementation of the act. Now, what is the implementation of the act? In broad sense, it is curbing any disaster, stopping the spread of any disease. Now, this also has penal provisions, Section 51, which you can see on the screen. Now, any person without a reasonable clause, if he is a reasonable cause, if he refuses to comply, he can be convicted if found guilty. Now, it also provides for a offense by companies. Before we move on to the next slide, Disaster Management Act does not provide for an express provision empowering a state or central government to make provisions such as directing private establishments to pay wages. Now, I will explain in the later slides why I'm stressing on that. Now, moving on to the government order issued by the state of Telangana. These are famously called the lockdown orders. They say there's an emergency in order to prevent the spread of virus, and tracing their power to these 2 acts, they issue these regulations. Now, it is important to note, under Regulation 7, they directed a closure of all shops, commercial establishments. Under Regulation 9, it exempted certain shops and establishments. Now, by exemption, I'm sure you must have perused the GO. The government order stipulates IT, banking, postal services, internet services, pharma, hospitals, and the various establishments enumerated there. ITES includes telecom, internet, and the other exempted services. Now moving on, now reading those regulations along with Regulation 14 is very important, which states that all the private establishments shall make full payments of salaries and wages fully. They use the word fully. That is why I'm repeating it again. It is not a literal extraction. We didn't extract it literally, but they use the word all the government and private establishments shall make payments of salaries and wages fully to the workers and employees, including contract and outsourcing employees during the lockdown period. Now, even though the preamble says it is till 31st March, the state government has been extending the lockdown from time to time. And the second portion of the regulation is also very important. Any violation will be viewed seriously and will invite penal action under the Epidemic Diseases Act. Now, Regulation 22 also entails a penal provision and says you will be liable if you violate any provision of these regulations. Now, moving on to the other government orders, which also stipulated similar conditions. I will move on to the central government orders, and these are also very important. I've only stipulated these three because, as you can see, the first one is a Ministry of Home Affairs order dated 29th March. Now, if we peruse that order, it says all employees should be paid in full by private establishments. Now, if we see the reason for that order, as you all know, when migrant labor in Delhi started moving and there was this, there was a possibility that the virus could spread rapidly, the Ministry of Home Affairs has come up with this orders which stipulate that payment of wages should be done fully. Now, circular number 15 is again very important. It is a circular of 10th April 2020. You can find it on the Ministry of Corporate Affairs website. There was a query put to the Ministry of Corporate Affairs whether an expenditure such as a wage to an employee during the lockdown period can be considered CSR. The Ministry of Corporate Affairs said no, but at the same time, it has answered a bit elaborately and said payment of wages during lockdown period is a moral or a contractual obligation and not a statutory obligation. Now, I will break it down for non-legal persons here. Moral obligation, contractual, the contract that you enter into, but not a statutory obligation. That is, the obligation to pay does not arise out of any of the statutes I have informed. So this is again, so we move on to the next thing you can see on the slide, that is an advisory. Now, advisories are issued by the Labor Department. They are not mandatory in nature. They only are directory and they advise you to pay the employees and they advise you not to terminate the services of the employees, but they do not impose a condition on you that you should not terminate or that you shall not reduce the wages. Now, why is that? Because they cannot enforce something under the Disaster Management Act and the Epidemic Diseases Act that is not permissible. Now, by something not permissible, I mean when there is no law, then there is no legal obligation. It is only a moral obligation. A government cannot enforce morals, like to say by way of these government orders, be it the state of Telangana or the central government, they're trying to impose a moral obligation. What is your moral obligation? To pay your employees. But is it a statutory obligation? No. Now, it all would boil down to the point that whether tracing their powers to these two acts, can they really issue such a circular? Then if I ask myself three questions, whether this act, such a condition is onerous, and can it be challenged? Yes, it can be challenged. And is there any challenge as on date? Yes. If you can see the news from yesterday, um, in Economic Times, you will find that Tools Corporation has challenged the Ministry of Home Affairs order that dated 29th March, directing mandatory payments, saying it is unconstitutional, and tracing their powers to the Disaster Management Act, they cannot impose such a condition. Now, moving on to the um, now, it is a more academic discussion, but I suggest all of you to keep a tab on and follow the case of the Supreme Court in in Tools Corporation. It is a MSME body that has challenged this order in the Supreme Court, and we should await the decision. Now, whether a challenge was made to the state government's order, so to our knowledge, in this lockdown, there is no challenge to the state government's order. Again, if there's any case that we come across, I would be happy to update you. Uh, Even though the central government order, if its challenge is allowed, the state government order would still hold good. And if a question is put to me, that if anyone would challenge it, I think in the near future, if any direction is issued by the Assistant Commissioner of Labor, or any proactive person who would challenge it for sure. Now, moving on to the remedies that are available to an employee, as you can see, it is better to negotiate first. Employees should also ask themselves a question: what is the industry they work in, the position they work in, whether they would fit into the meaning of into the meaning of Minimum Wages Act or the Payment of Wages Act, or they come under the purview of the Telangana Shops and Establishments Act. Then, if it's a factory, you can always approach the Works Committee, any industrial internal grievance redressal mechanisms. If all these do not work out, in a Shops and Establishments Act, you can always challenge an illegal termination. As you can see on the screen, an ITS employee can approach the Assistant Commissioner of Labor, and they have the power to reinstate. Now, so far as the other acts are concerned, a claim can be made under the Minimum Wages Act. A claim can be made under the Payment of Wages Act. Again, the Assistant Commissioner of Labor is empowered. Depending on the claim, you can also approach the Joint Commissioner of Labor. Under the Industrial Disputes Act, any dispute between an employee and employer, which falls within the meaning of an industrial dispute, which is again stipulated under the Act, you can approach the Industrial Disputes Tribunal. The Assistant Commissioner of Labor might hold conciliation proceedings. Under the IDA Act, there are conciliation officers. You can always approach them, but if nothing works out, you can always have the remedy of approaching the tribunal or the Assistant Commissioner of Labor, who is the appointed authority. Now, the employees who do not fall within the meaning of these acts might have a question on how the disputes they face should be governed. Again, it is a contract, and if they do not fall under the purview of any of these acts, say a managerial position person, can always approach the civil court and file for damages and any other claim. Now, moving on to the remedies available for an employer. The first thing I would ask the HR personnel to look into your contracts. Yes, a lot of persons writing contracts did not stipulate such a situation, but there would be a force majeure clause. Look for clauses which say act of God. Now, the second point that you can see on the screen is more of a legal argument, and again, it would not fit into we cannot enlarge the scope of this webinar, but you can always look for such clauses, see to it that you can invoke in the worst case. But before that, it is better to negotiate with an employee, have his consent, enter into new contracts by carefully seeing that you comply with the contracting out provisions I have informed you that are there in various acts. Now, why do I say this? Because if the contract contains any clause contrary to the act, that so far as that portion is concerned, it would be void. Now, legality of a mandatory payment like the one issued by the Ministry of Home Affairs or GOMS 45 again is a disputed question. Let us wait for the outcome of the Supreme Court, and I'm sure challenge is not very far for the state government's order in the concern in our High Court. Now, as an advisory, it is best to leave the blue-collared workforce. It's always better to start cutting costs from the top, not the bottom. And these are some things that you can always do. Promising a rehire first to a retrenched employee, terminating a last in first out policy, and while availing disputes under the industrial dispute, while availing remedies under the Industrial Disputes Act, I always call upon all the HRs to comply with the provisions under the Act. Now, whether that now coming to the more important questions, whether you should pay the employee now. Yes, because GOMS 45 has a binding force, but looking at the act of this state government itself, without entering into any controversy, the state government wanted to defer payments, and that drew flack. Now, when the state government says that private establishments should pay, and the clause also talks about government employees, can they do this? Is a question that would plague in your mind. According to me, a challenge is not far away, and once it is challenged, the legality should be tested in the touchstone of whether the government is empowered under the Disaster Management Act and the Epidemic Diseases Act. Although I hate to say this, but on a legal argument, I don't think it would stand the test, and the provision directing mandatory payment might be set aside. And now we should wait for the outcome. But however, until the outcome is there, I would direct employers to pay in full. If not, it is always good to negotiate with an employee, and you enter into new contracts with the consent of the employee. If a termination is unavoidable, leave the blue-collared workforce, and if you have to terminate them, follow all the regulations under the Industrial Disputes Act and the Telangana Shops and Establishments Act. Now we are running out of time, and this is the entire webinar. I hope I have answered your questions, but if I've left out any specific questions, there's a Q&A session now. You can pose your questions in the Q&A option available on the top left of your screen. Now, coming to a Factories Act, there's no specific provision, but again, as I told you, the GO would apply. There was a question that was asked. It only said, "What about Factories Act?" I've given you the various provisions under the Factories Act, and if it's a dispute, it will be under the Industrial Disputes Act. The various provisions that are there, a lockout and a retrenchment and all. Okay, so we have a question. So minimum wages should be paid in the negotiation also. I deem that question is asked in the context that if you negotiate with an employee, should you pay the minimum wages? Yes, you cannot pay something less than the minimum wages if the act is applicable. Now, This is a very interesting question. How much percentage of salary can be reduced from an employee? Um, it, I would say, be reasonable. If you are reducing, let it be in a uniform manner. Do not do more than 50%. Now, if you decide to pay wages, can I exclude house rent allowance? House rent allowance, yeah, if you see, it would fit within the meaning of the exclusion of the term wages. So, yes. Someone who's talked has a question with regarding to section 71 to 73 of Disaster Management Act, which gives powers to government to give advisory orders. Yes, but you should understand the context in which a Disaster Management Act is enacted. Anything done by the government to prevent the spread of a disaster, an epidemic disease, should be correct. But would they have wide amplitude of powers to impose a mandatory payment is what we have to look into. Now, there's a question posed which says, in case of termination, where the services of an employee is terminated by or on behalf of the employer, the wages earned by such employee shall be paid before the expiration of the second working day from the day on which the employment is terminated. Now, in case of non-performance of employees, okay, do we still do we have to pay on next working day? But again, what would be a non-performance? So, if you are in IT, for example, if it's an ITS industry, I would say non-performance would not fit into your case, or if an employee can work from home, you cannot say he's not performing his part of the contract. You cannot say he's liable for non-performance. Now again, the person who was asked about section 71 and 73 has posed section 71, bar of jurisdiction. It gives an exception to Supreme Court and High Court, and you can challenge the orders issued under the Act. Now, this is an interesting question. In case of an ITS employee, he did not work from home. Can it be treated as non-performance? Now, look into the individual contract, the nature of employment. Did he have the means to perform work from home? Is what you should look into. If he did, you can say it is non-performance when he had the means to perform it and he did not. Now, due to the volume of questions, I am not able to read one question at a time. Yes, can management take a decision on how much to deduct? Yes. It is again subject to the consent of the employee. Now, we have a question here which talks about a force majeure clause. What if there is no force majeure clause? Then it's a more legal argument. You can look into section 56 of Contract Act and section 32 and a few of the important case laws, one being between the Central Electricity Regulatory Commission of the year 2017, which talks about frustration of a contract and in what circumstances the doctrine of frustration can be invoked, that is impossibility to perform. When there is no force majeure, you can look into these aspects, but again, when the lockdown is over, there would be a possibility to perform. So it is an academic point of discussion. See, again, Ministry of Home Affairs order is saying payment is mandatory, correct? But whether they can impose such a condition, I don't think so. They cannot. In my opinion, it is a no. Now, you are forced to pay, but you can always challenge. And as is the case, it has been challenged before the Supreme Court. Let us wait for the outcome for the ministry, for the challenger to the Ministry of Home Affairs order. Now, one more important question that is asked is, the employees are forced to go on leave without their consent. If you do not consent, you would always tell your employee that you are ready to work, and all the you have all the equipment to work from home. And in that case, if the employee um, is directing you to go on leave, you can always ask for wages, and you can approach the Assistant Commissioner of Labor. But if you consent to that, the consent is very important. So you should not consent to the directions of your employee in case the employee is forcing you to go on leave if you want the full wages. Can we pay minimum wages to all our employees? Um, if you can show to the court tomorrow that you did not have any means to pay, there is financial inactivity. I understand the position various employers, business personnel, CEOs are in, that there is no revenue generation. In these circumstances, if even though the order is binding, if you take an action of reducing the wages, do it with the consent of the employees. If there is no consent, and tomorrow such an action is questioned in the court, if we can always defend saying the action was reasonable and you paid minimum wages for the survival of the employees and for the survival of the company. Now, what would be a reasonable action that you can take is, you should take into account the interests of the employees and the employers and balance it out. Now, again, to tell you about the MHA order, it was issued in the pretext of the migrant labor, and we can always argue that it is not applicable, but as it stands today, it has a binding force. There is another question from a personal. He's asking if the consent should be written or black and white. It's always better to take a written consent from the employee for the reduction in wages. Yes, consent by email is accepted. A question is put whether the consent can be obtained by email. Yes, it is accepted. Now, as we talk about the force majeure question that is asked again, it is a more legal argument. It is not only for the purpose of employment contracts, but all the other contracts that you might have entered into with your in the course of your business. If there is impossibility of performance, you can always invoke all the force majeure clauses. Again, that is on a case-to-case basis. As per payslip breakup, can we negotiate with machine shop and staff employees of their basic pay? Yes, you can. Will the deferred salary be mentioned? If you want to defer the payment, and if you obtain the consent of the employee, you can always defer it. It needn't be in the payslip. You can always have a separate contract for it.